Well, the automatic stay is triggered upon the filing of the bankruptcy papers. Now, I mentioned a little earlier that if you've had prior bankruptcy cases during the 12 months prior to the filing of the current case, there are limitations on the automatic stay. If you've had one, then you have to get the judge to sign an order reinstating the stay. Otherwise, on day 31, it doesn't exist. And if you've had more than one, there is no automatic stay. But assuming that you haven't had a prior case pending during the 12 months prior to the current case, the automatic stay takes effect and remains in place until either the creditor in question successfully moves the court to lift the stay, or you get a discharge and the stay is replaced by the permanent discharge injunction. Now, with regard to moving the court to lift the stay, just because you file a motion for relief from the automatic stay does not mean that the judge will grant that motion. You've got to have a good reason. And if the reason is that you just want to keep on going with a wage garnishment, chances are you're not going to succeed with that sort of motion. There are motions for relief from stay that are very successful. For example, let's say you just haven't been making your car payments and you file the bankruptcy petition. The creditor would like to come and pick the car up, and you have made no provision in your bankruptcy papers to keep and cure the arrearage and make payments. Let's say you've even gone so far as to say you want to surrender the vehicle as part of the bankruptcy process. Well, the creditor cannot come and pick the car up while the stay is in place. So in that situation, the creditor will file a motion for relief from the automatic stay and ask the judge to lift the stay just for the limited purpose of retrieving the car. And that type of motion is granted just as a matter of course. Another may be the creditor has been suing you in California Superior Court. You filed the bankruptcy petition that stayed that California Superior Court action. The creditor would like to resurrect the action and proceed at least to judgment. And so the creditor can file a motion for relief from the automatic stay to have that stay lifted for the limited purpose of completing the state court action. There are other types of typically successful motions for relief from the automatic stay, but if there is no motion for relief from the automatic stay, then the stay remains in place until the time you get your discharge. And then once you get your discharge, as I said earlier, the discharge injunction replaces the automatic stay and forever prohibits a creditor from being able to collect on a discharged debt. Now, if there are debts that were not discharged, then the creditor is free to resume collection actions against you on those non-discharged debts. For example, let's say you owe student loans. Student loans are typically not discharged in a bankruptcy case unless you are successful in an adversary proceeding to get them discharged. So while the automatic stay will stop the lender from being able to collect on that student debt, once you get your discharge, the automatic stay terminates, is replaced with a permanent discharge injunction, and then the creditor can resume collection actions.